Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another episode of Legal Ease, the show that converts legal jargon into legal ease. Tonight we'll be covering the topic of legal costs and how one can deal with it. How does one take costs into account, and what is a client expected to pay, how legal costs work, how attorneys charge out their fees, what agreements you could reach. So it's a very, very interesting topic. And tonight we're going to be doing things slightly differently because I have a very special guest with me in the studio. I will introduce him to you in a little while. What I'd like to say up front regarding tonight's program is that the Afrikaans viewers will be very glad to know that you could call in with your questions in Afrikaans. In fact, my guest and I both would be speaking in Afrikaans, not for all of the show, but for some of the show, just to give you the indication that you must feel very comfortable if you need to ask any questions in Afrikaans. If you could just bear with me, I understand that we have breaking news. I understand we have Nadeem, who is my co-host on Legal Ease. Nadeem, can you hear me?
Ji, I can hear you. Assalamu alaikum. Ashraf, how are you, brother?
Wa alaikum salam, Nadeem. I understand you have some breaking news for us.
Yes, Ashraf, jazakallah for giving me the opportunity. And, I don't know if you remember, but last week we did the show on international law, but primarily focusing on those anti-terrorism laws of the UK and the USA.
Yes.
We had in studio with us Professor Henny Stradom from the University of Johannesburg.
Yes.
Now, the viewers would remember that last week, on the 25th of February, a very important friend and colleague and guest of ITV, or should I say of Legal Ease, Muazzam Beg, was arrested and detained in Birmingham and is currently being held in the Birmingham police station in London, in the UK. And you remember also that Muazzam Beg was a former detainee of Guantanamo Bay, and he was arrested after visiting Syria. And he visited Syria, and when he returned to the UK after visiting Syria, they took his passport away, and shortly thereafter he was arrested. So the Muslim Lawyers Association has actioned quite a big support and a massive gathering and following to assist both in the United Kingdom and in various other parts of the world. And CAGE UK, which is the organization from which Muazzam Beg was the research director and in fact the co-founder of that organization, they've actually requested an International Day of Action. Now, one would be asking, what is this International Day of Action all about? Well, it's quite simple. The United Kingdom and the United States of America have what we all know is called anti-terrorism laws. But in plain fact and in plain English, those are not anti-terrorism laws. Those are quite simply anti-Islamic laws. So the war on terror, as they like to put it, is not actually a war on terror. It's quite simply a war on Islam. Now, there isn't much that we can do from a due process perspective, because let's remember that they are following due process. It just happens to be their due process. It happens to be legislature of their countries, and they are following that legislature by the book. The problem is, and this is something that's very important, the Muslim Lawyers Association, we do not, under any circumstances, encourage non-compliance with laws. We simply say that we will not follow unjust laws. And laws that can detain only Muslim people under their legislation is not only racist or segregatory or apartheid in nature, but it is also an absolute crime against humanity. So the Muslim Lawyers Association have organized a memorandum, have prepared a memorandum which they will deliver to the British consulate in Dunkeld West tomorrow. That is in number 275 Jan Smuts Avenue, that's in Johannesburg, and that memorandum will be accompanied by a picket. We're expecting to gather in the region of about 200 to 300 people for this protest, and we are saying once and for all that Muslims will unite, Muslims must unite. And if humans all across the world, Muslims or non-Muslims, are listening and are watching this, it is important for them to know that this is not just a Muslim issue, it is a humanitarian issue. And the Muslims will stand by their principles and foundations and will fight for those principles and foundations. So we are asking for the support of the Muslim Ummah, the entire community, the entire Muslim world. And in many parts of the world, this protest will go on, and inshallah it will happen tomorrow between the hours of 12 and 3. Once again at number 275, Jansmat Avenue, Dunkeld West, outside the British Consulate.
Thank you, Nadeem. So just to recap, what you're suggesting is that you would like people to join in with you on this, or is it a protest that, or is it a memorandum that's going to be handed over?
Yes, it's a protest. It's a protest and a picket, and during which we'll be delivering a memorandum, handing over this memorandum to the consulate.
Okay, thank you very much, Nadeem. Is there anything else you wanted to add?
No, that's all. Jazakallah Ashraf for the time, and inshallah we will get a vast gathering tomorrow. And like I say once again, if I can just leave you with this, that it's really for Muslims to unite and for the world to actually see what's going on.
And this is a campaign spearheaded by the Muslim Lawyers Association?
That's correct, yes.
Okay, Nadeem, thank you very much for calling us.
Jazakallah khairan, Ashraf. Assalamu alaikum.
Alaikum salam. Okay, so viewers, you've heard the message. That was a breaking news item that we've heard from Nadeem regarding a protest action that will be taking place between 12 and 3 in Dunkeld regarding the recent arrest by the British authorities of Moazzam Beg, who was a ex-Guantanamo Bay prisoner and a member of CAGE, and he was a guest on our show as well. And now back to our regular programming. So prior to the taking of the breaking news, I was indicating that we'll be talking about the question of legal costs and what it means in the legal context. How does one litigate and how does one account for costs? And my very special guest tonight is Hyder Rosslee. Assalamu alaikum, Hyder.
Walaikum salam.
And welcome to Legal Ease.
Thank you.
Hyder has been an attorney practicing in that particular field of specialization for over 30 years. He practices in Johannesburg under the name Rosslee and Lion-Cachet. He's well known in the legal circles as he's one of the experts that one consults when you have a matter dealing with legal costs. En soos ek nou vroeër gesê het, gaan ons bietjie ook in Afrikaans praat. En Hyder is baie gemaklik om ook in Afrikaans te praat. Dis sy moedertaal, en ons wil vir die mense van die Kaap of oral sê, julle kan in Afrikaans ook vir ons bel, en die nommer, soos julle altyd weet, is 011 086 7701 of 3. As julle wil, dan bietjie later in Afrikaans vrae gee of enige iets wil vra, julle kan maar maklik in skakel. Hyder, with regard to the question of legal costs, now you know most clients, when they have a conversation with an attorney, the structure of legal costs is not always clear. But legal costs is particularly dealt with in civil matters, is that correct?
Predominantly.
Predominantly.
Yes, predominantly.
Okay, now let's try and talk through some of the issues or some of the structures. What kind of costs does one have normally?
Well, Ashraf, there's because of our system of the adversarial system of law, when a person is successful in a civil matter or predominantly civil matters, they will be awarded costs by the court. Now, we follow the English system where those costs are not quantified by the court itself. It will be left to what we in our business call a taxing master. Right. He or she is a registrar of the Supreme Court or of the Magistrates Courts, who will quantify those costs in a separate procedure. There will be a bill of costs drawn, so very similar to a bill of quantities in the building industry. The work that an attorney had done in order to bring the matter to court, all the work that was put in so that the matter is ripe for hearing, those costs will be quantified in terms of tariffs that is promulgated by the government in the actual High Court or the Magistrates Court Acts. And those costs will be used, or those cost fee structures will be used in order to draft a bill of costs.
So, for example, in the Magistrates Court, when you have 3 levels of, let's say, value on a particular matter, for example, district courts have an upper cap of 100,000, and then regional courts between 100 and 300,000, and then from 300,000 onwards, your jurisdictional limit goes to the High Court, unless you agree in writing before that you're going to be using, irrespective of the amount, you're going to be using the Magistrates Court. But in the Magistrates Court itself, there are 3 levels. There's A, B, and C. So the first amount is between 0 and 7,000.
That's right. It's kept at the Small Claims Court jurisdiction. In other words,
which is now 12,000.
Which is now 12,000. But they have brought back the Scale A jurisdiction to 7,000. It used to be 12,000.
Right.
It's now brought back to 7,000. So claims sounding in money from 0 to 7,000 rand would be taxed on the Scale A, as we call it.
Right.
Claims between 7 and 50,000 would be dealt with on Scale B. Any claims between 50 and 100,000 would be Scale C, and then the regional courts would be, and there's a 4th scale now, Scale D.
Right.
And those costs, or those tariffs will be used depending on your judgment, the judgment amount in the Magistrates Court.
Right. So typically, let's say you sign a contract, and the contract stipulates that in the event of let's say the seller introducing or instituting action against you, you'll be liable for costs. Now, let's say the contract doesn't say costs on this particular scale. Then typically, are you liable for just attorney, what we call party and party costs on the lowest level? Or can the seller still dictate later, no, look, I didn't say that, but now I want to charge you all my costs for having gone to my attorney? Or what's the rule there?
Well, just to explain it, there's 2 types of costs that can generally be recovered by the successful party from the unsuccessful party.
Right.
Those are party and party costs, which is the general, in the vast majority of cases, when the courts make an order and say that the loser must pay the successful party's costs, that would mean party and party costs.
Right.
If the court intends, for whatever reason, and you've referred to one of those reasons, if in a contract it's contracted between the parties that attorney and client costs will be payable in case the matter goes to court, then of course the court will, pursuant to that clause in the contract, will award attorney and client costs. It doesn't have to.
Yes.
But generally they will follow what was contracted between the parties. So an attorney and client order will then be granted. There is a difference between the 2. The party and party costs are, as I alluded to earlier, is in terms of the tariffs that's promulgated by the government. Now,
right.
Those tariffs are adjusted from time to time, but they are not really keeping up with the pace of costs,
right.
You know, that attorneys charge. Sometimes those fees are only adjusted every so often, 8 years maybe.
Yes.
The longest that it's taken is 8 years between 2 tariff increases.
Right.
So you will appreciate attorneys can't for
Yes.
8 years charge the same fees.
Yes.
They adjust their fees yearly like anybody else. And then there's attorney and client costs, which gives you a fuller indemnity. You know,
Right.
you will never recover all of the costs that you've invested in a matter.
I think that's a very important point that we need to come back to. Because there's a perception that, look, I given my attorney 100 rands, and when I recover, I must recover that 100 rand, but we'll come back to that point. So you were saying that there's a clear distinction between what the tariff dictates with regard to party and party costs, and we're going to talk about that in a little bit more detail, and what we call attorney and client costs. So attorney and client is on a different level.
It's a different level. The difference essentially between party and attorney and client costs is the successful party will not necessarily only recover that which the tariff indicates.
Right.
If the tariff indicates 852 rand an hour, you might recover more, depending on the matter again, you know, the complexities in the matter. So there's various factors that,
Yes.
that deal with how much more you will recover. But you would generally recover more than what the tariff suggests you recover as between party and party.
Right.
As between party and party, obviously, will only recover that which the tariff makes provision for.
So obviously, in the difference between attorney-client and party and party stipulates certain necessary things you could charge for, but that rule doesn't apply to attorney-client. Is that right?
That's the other difference between party and party and attorney and client costs. Not only just the rates, but there's also certain items which can never be recovered as between party and party. Those would be work that an attorney would do mostly on the instructions of a client, which is not strictly necessary in order to bring the matter to court. It might at that time be necessary, or it might seem to be necessary, and later on turn out to be not necessary to use that information that was gleaned.
Just to give a practical example, let's say it's an obscure part of the law, or it's a part of the law that's developing. With regard to attorney-client costs, would you be able to say charge your client for research purposes?
Well, not to put a too fine a point on it, but attorneys would normally be asked by clients to give an opinion if the law is not clear, you know.
Right.
And that would mean that an attorney would have to go and do research and then provide an opinion. As between party and party, generally, there are circumstances and there are certain types of opinions that would be allowed as between party and party, but to research, let's call it the prospects of a client being successful in a matter,
right,
would not be recoverable as between party and party, but as between attorney and client, it would be recoverable. And
okay.
that's another difference of...
So that's a convenient spot to pause, and we're going to an ad break, and we'll catch you on the other side of this short break. Stay. Assalamu alaikum, and welcome back to the Legal Ease program. As previously stated, the guest tonight is Hyder Rosslee, and he is very conversant in Afrikaans. So if you need to call in regarding any questions regarding legal costs, which we're trying to unbundle tonight, please do so. And once again, the number is 011-086-7701, 2 or 3. Hyder, we were talking about costs, attorney and client costs, and the difference between what party and attorney and client. But it appears to me that what you're saying is there's no clear-cut rule. A lot of it is discretionary.
That is correct, Ashraf. The taxi masters, as I've said earlier, who attend to this process of taxation or the quantification of the costs, they are clothed with a discretion. It's a very difficult thing to describe to people, but they will look at the facts of a matter, and they will then decide that this is a matter that's of legal complexity or factual complexity, or both for that matter, or for that matter there is no complexity, and they will then tax as a result of those findings. They will allow more where the matter is more complex and where the matter is, whether it be in law or in fact, or they will allow very minimal attendances when the matter is of an average nature or less complex nature. So that is the discretion that taxi masters are clothed with in order to allow. When it comes to the attorney and client costs that they'll allow, that is where the discretion will kick in on how much more than tariff they would allow.
Right.
You know, if they decide that the matter is worth more than the promulgated tariffs that the government has suggested as between party and party, they will then decide that the matter is maybe worth 1.5 times tariff or twice tariff or any random amount. You know, that they're very experienced in looking at matters and deciding that this is on a scale of 1 to 10 a matter that warrants so much more than tariff.
So, and the third category of costs would be what you as an attorney agree with your client as your hourly rate, and that's known as attorney and own client costs. And there you're not necessarily bound by the tariff. You can agree to an amount.
Absolutely. Generally, an attorney would, at the first consultation with a client, advise the client of his rates that he would normally charge.
Right.
He would also advise the client that there is a tariff which is applicable when he recovers his costs, and he would explain to him that there's a difference between what the attorney will charge his client and what the client will recover eventually from the other side if he's successful.
Right.
So an attorney would then contract out, as we would say, out of the
if you use the example of medical aid,
that's it.
There's a government tariff.
That's it.
But you as the doctor don't have to stick to that tariff. You can say to your patient, look, you're going to pay me this amount, and that's my hourly rate, and I'm not charging your tariff. So in a very similar way, the attorney and his client can reach agreement. Now, there's been a very, very interesting case recently in the Constitutional Court, which seems to have settled, I think, once and for all, the controversy surrounding charging, let's say, common law agreements and what contingency fees really are. And I'm referring to the case of Bobroff and Partners in the Constitutional Court. Can you just explain to our viewers what that dealt with and what was the court's finding?
Well, Ashraf, quite recently, as late as 1995, the government thought it proper to, in order to make it more accessible for indigent clients especially, or for clients who could not afford to do or to pay for litigation.
Especially in road accident.
Especially in road accident fund matters, where there's a claim sounding in money.
Yes.
That the client and the attorney could contract on and to put it in layman's language, a no-win, no-fee agreement.
Right.
Which is also known as a contingency fees agreement, contingent upon the fact of whether you win or not, the attorney may charge a certain amount.
Right.
Now, the Contingency Fees Act, it's quite a complex matter. I'm not going to go into detail, but just as a matter of interest, the attorneys are allowed, the Act allows an attorney to charge up to 25% of the eventual judgment that's made in favor of the client. But there are some safeguards in order to not overreach a client. In other words, not to charge a client more than what the matter is worth.
Right.
Attorneys must still prove that if they had contracted on this, what we've alluded to, the contractual basis of X rand per hour, that if he had charged on that basis, the 25% that he's entitled to in terms of the Contingency Fees Act is not more than double what his normal fee would have been.
Oh, his normal fee.
His normal fee. If his normal fee on an hourly rate would have been, say, in that matter, to bring a matter to court, 100,000, then if the 25,000 rand, 25% in terms of the Contingency Fees Act, if that amount is, for instance, 250,000, he will not be allowed to charge it 250,000. He will be limited to 200,000, which is double what his normal fee would have been.
Which is which is his normal rate plus 100%.
A normal rate plus 100%. Yes.
So that's very interesting. So, notwithstanding the fact that you could have contracted for more in terms of the Contingency Fee Act, there's another safeguard built in that you can't just go and double or triple your normal fee just because you've agreed. You are still, the ceiling for you would be your normal fee plus 100%.
Plus 100%. That is again, especially in large road accident fund claims, where a client would be successful to the tune of 5 million rand.
Yes, yes.
And an attorney would then say, well, I'm entitled to 25%, but he will not be, because he will not be able to prove that his normal charges plus 100% would come to that 25%. So the client would be further, he will be, the attorney will not be allowed to charge the 25% of a 5 million rand award.
Okay.
He would only be allowed his normal fee plus 100%.
Well, I think that's a very, very important development. And viewers are once again invited to call us regarding the questions. Any question you would have about legal costs, how it works, what does your attorney charge, what is he entitled to charge, what happens when you win a matter, what happens when you lose a matter. Is it always that the costs follow the result, or is there a break from that formula? And as always, our number is 011-086 7701/2 or 3. Now, Hyder, we were talking about that very, very interesting and I think significant judgment. Now, let's say I have a non-litigious matter with my attorney. I approach him and I say, look, I'm signing up for this contract and it's a franchise agreement. Now there's no tariff, right? So the attorney says to you, okay, I charge 1,000 rands an hour. And let's say you budgeted, say, 12,000, but the attorney spent 100 hours and the bill came to 120,000. Now, is there some way of trying to find a way of finding a comfortable middle ground for both attorney and client?
Yes, the circumstances that you've suggested here would be allowed. The taxation would happen at the Law Society's Fees Assessment Committee hearings.
So this is that there's no, it doesn't go to court.
This
There's
will,
no
this
master
will, yeah.
that
The taxi masters will not tax that bill because
Right.
there is another person that is entitled to charge to tax this bill.
Right.
It being the Law Society Fees Assessment Committees. Generally, a client, if he's dissatisfied with what an attorney has charged
Yes.
him, will lay a complaint, and the Law Society's procedures will be explained to him when he asks, how to lay a complaint.
Right.
The Law Society will then obviously involve the attorney and ask him to give an explanation. And if they find that there is a necessity to do an assessment of his fees,
Right.
a committee will be constituted, and the client's representative or the client himself is entitled to come to this meeting. The attorney will come, he will bring his work, his file, and he will justify the fees that he's charged. He will
Right.
prove what he has done, and the assessment committee will ask questions, and they will then go away and will make an assessment of what the attorney's reasonable fee should be or would have been.
And he's bound to that.
And he's bound to that, yes.
Okay. Now, there's obviously a very high-profile case going on at the moment, a criminal trial, which, because it's sub judice, we would not be discussing. However, typically in a criminal case, the accused has to spend a huge amount of money investing in an attorney to conduct his defense. And the state acts for the complainant. So the complainant has got no real fees. He doesn't have to pay anyone, the prosecutor or anyone else, investigating officer, to take the file and look after the file and make sure it comes to court or do a good job on it. Now, in the event that the accused is found not guilty, can he recover those fees from anyone?
Ashraf, generally not. There is no cost orders in criminal matters, or generally there is no cost orders, I must specify. There are, however, occurrences where, and I'll give you a few examples, where it was found that the prosecutor was malicious in persisting in the prosecution when he should not have. When the facts come to light that maybe the accused is not guilty and therefore he shouldn't proceed with the prosecution, but he does.
I ask you to pause there. We have a caller in the line. Caller, Assalamu alaikum. Okay, the call come back to us. So we were saying that it's not generally the rule that in a criminal matter you'll be able to recover your costs, but that rule can be diverted from.
That's right. And if it's found, and the court will then make an order, if being addressed by the accused's attorney, the court will then make an order that the prosecutor in fact might be liable himself for the costs, or the state for that matter. Might either make the state liable for those costs or the prosecutor himself.
So that means the prosecutor might have to pay from his own pocket.
It's happened before, but it's a very rare occurrence.
And under what circumstances would that happen? I mean, it must be very extreme if the
extreme malicious prosecution.
Is, yes. Okay, so it's extreme and malicious. So it's not as if the prosecutor, for example, turns up drunk at work. I'm just giving a very weird example that if he was not able to conduct the matter properly because he was drunk or on medication, and you felt that he didn't ask the right questions to the accused, or he didn't defend the witness vigorously by objecting, those things would not necessarily mean that he didn't do his job properly.
That's correct.
It's malicious, so it's actually quite narrow. Only if he's malicious,
and which is very difficult to prove. It's very difficult because a prosecutor will have to do his job obviously to the best of his capabilities. And sometimes they do overstep. They get too involved in the matter maybe, but that's not a reason to mark him with the costs. But where it can be proved that he was maliciously prosecuting the accused beyond any reasonable prosecutors, where a reasonable prosecutor would have gone, then the court can won't necessarily do that,
Yes.
but it can if it's asked to, and if it feels that there is a case for malicious prosecution,
Yeah.
they would then order the state to pay the cost, or in very extreme cases, the prosecutor himself.
And what about costs in other forums outside the legal forum? So, for example, in the Competitions Commission, in arbitration proceedings, is there a similar rule regarding cost, which is that the costs follow the result, or what about the CCMA?
Well, the CCMA generally does not allow, as far as I'm aware, legal representation, or only in certain circumstances.
In fact, there's been now quite a big shift. In fact, you are allowed legal representation.
Yes. But the cost orders will not necessarily
Not
be
necessarily,
made, because it used to be a procedure where it was more of a conciliatory meeting,
yes.
and trying to get the parties to talk.
Yeah.
And therefore they very rarely granted cost orders.
Right.
But there has been cost orders. I've actually appeared in the CCMA on occasion, but very rarely as well, because there are not that many orders made by the CCMA.
Now, in the event there's a cost order in the CCMA, or there's a tender of costs. I mean, I had a matter recently where the respondents didn't really come to court on time, and then they tendered the costs of the postponement. Now, what guides you? What kind of costs? Where do you find those costs?
They actually employ the magistrates' court rules and tariffs.
I see. So it's back on the magistrates' court.
And again, it's on those guidelines of the quantum of your claim.
A, B, or C.
A, B, or C, or sometimes even D.
We have a caller on the line. Caller?
Yes.
We can hear you. Please go ahead.
Hi, Salam. My husband has told me he wants 3 talaqs, right? We're living in a council house. What is the chances of him evicting me with the 2 children?
Okay, it's slightly outside the ambit of our discussion tonight, but I can tell you it's very, very difficult for your husband to succeed in evicting you, a mother, and 3 children from a house that doesn't belong to him. Did you say a council house?
Yes, it is a council property, but if he does give the talaqs, right, he's haram to me, so we can't live in one house.
Then he should leave.
Because, yes, because he's the one cheating.
No, but he should leave. It's not about you can't live in one house. Let's just think about what the law provides here. The law provides that no one may resort to self-help. So if he's the owner of the house, he'll have to go to court to take certain steps to evict you. However, the court is going to take into account you, the mother, the primary residence of the children is with you, and the court is the upper guardian of all minor children. So the court is there to protect minor children. I see it very, very unlikely that he would succeed in evicting you with a court order. And if he resorts to unlawful extrajudicial means, well, you can go to court and have that whole order reversed. Thank you for your call. Hyder, we're now talking about unusual cost orders. Let's say now we're talking in the CCMA, and you said that the tariff is that of the magistrate's court. So let's say theoretically my client is claiming 200,000. So that would be above the district court tariff and below the regional court tariff. So would it be on that new scale D that you spoke about?
That would be the scale D, yes.
Okay. So typically, when you're drawing up a bill, from at what stage do you draw up the bill? Do you draw up the bill that your client telephoned you? Let's just take the lowest, right? Party and party. Attending call from telephone call from client. Consultation, first consultation. Now, that consultation, depending on the scale, is limited to a certain amount. Now, let's say after the consultation, you had to draw documents for your advocate, and you copied those documents. Those costs would be allowed.
That would be allowed, yes.
And let's say you then drove to Sandton to meet with your counsel. Is that cost allowed? You're driving to counsel?
Not as between party and party.
Not between party and party. Okay. So although it was necessary for you to drive to counsel, it's not a cost that it's recoverable in terms of the rules regarding to party and party costs.
Right. The tariff does make provision for travelling, but only under certain circumstances.
Right.
Generally, those circumstances would be when the attorney goes out to do an inspection in loco, because the inspection cannot come to him. He has to actually get in his car and go to the accident scene or where the inspection and local is
so that talks to that point that you were saying you will not recover all of your costs.
That's one example.
Yes. So let's say I went to court and the court didn't start at 9 o'clock but started at 12 o'clock and I had to sit in the passage and wait. That's normally referred to as waiting time. Well, what's the rule there? Am I entitled to claim on party and party or on another scale waiting time?
Generally, the tariff doesn't make specific provision for waiting time, but the taxi masters, and especially because they are registrars of a court, know that it's not an ideal world. Matters don't start exactly on 10 o'clock, and there are times when the legal teams have to wait around until their turn comes. So they've developed a practice, even though the tariff does not make provision for it, they've developed a practice where they've held that they will allow waiting time, but because the attorneys are not employing their legal acumen at that time, they will actually do it at an even lower rate than what the party tariff provides for. But at least there is a partial recovery of the time that you've spent, or partial recovery of the money that's payable by the client that the attorneys would have spent waiting for the matter to come on.
Now it often happens when counsel is employed, and this might change with the introduction of the Legal Practices Bill, which basically will remove the distinction between attorneys and advocates. And what will happen there, I have to pause and take a caller. Caller, please go ahead.
Assalamu alaikum.
Walaikum salam.
Can I speak Afrikaans with deze
Ja,
gentleman?
gaan maar voort, dankie.
Ja, ik wil nou net voor hem explain. Als ik ik was naar die attorney toe gegaan. Die attorney ik heb al een ronde gezocht voor een attorney, want ik heb hier geld gehad om voor hem te betalen. Toen ga ik bij die firm en die firm zei voor mij dat hij gaan doen pro bono. Maar het is een firm wat het gaat doen. Maar nou is attorney wat werkt voor die firm. En ik heb voor hem gezegd, oké, als hij heeft wat betekent pro bono, toen zei hij, je moet net een certain amount geven, zeg zo about 60 rand of zo, moet je geven om die court orders te betalen. Ik heb dat gedaan en toen hij nou samen met die mensen nou arrangement gemaakt dat hulle moet vir hom betaal. En hy gaat vir hulle 'n court order gee om uit die huis uit te gaan, maar dan moet hulle vir hom betaal by die office. En ons het dit geaccept so dat hulle gaat vir hom betaal by die office. Agter omtrent seker 6 of 7 maande, toe kry ek 'n summons dat ek moet 10.000 rand betaal vir die firm, omdat die firm gewerk het vir hulle om die goeders te doen. Ik zei, maar toen ga ik naar die firm toe, toen ga ik voor die firm vragen, wat is aangegaan, hoekom moet ik die geld betalen? Ik heb hier geld om te betalen. Toen zei hulle voor mij, en die man, en die attorney werk je meer daar niet, want die baas heeft die attorney gefeierd. Nou wil hij die geld bij mij. Ik zei, kan ik samen met die baas praten? Dat ik voor die baas kan zeggen? Die baas zei, nee, jij moet het niet betalen. Zo voor die attorney. Ik zeg, weet je waarom je attorney te krijgen niet?
Oké, kom ons zien of ons kan helpen, mevrouw. Kom ons zien. Hyder, wil je een beetje daarover praten?
Ja, mevrouw, u heeft altijd een recht om voor uw procureur te vragen, of dit nou die procureur is dat oorspronkelijk die werk gedoen het, of in ieder geval die firma, om vir u 'n rekening op te stel. Nou, ons noem dit in Engels 'n bill of costs. Om 'n rekening op te stel en om daardie rekening te takseer. Ons het vroeër vanaand gepraat oor die taksasieproses. Hierdie klink vir my soos 'n saak wat na die hof toe gegaan het. Dit was 'n uitsetting of
ja, maar dit wat hulle by die hof toe gegaan het. Toe ek by die hospitaal.
Ja. Ja, maar
mevrouw het gesê by die eerste punt, hulle het gesê hulle doen dit pro bono.
Ja.
So daar is firmas wat nou pro bono werk doen. Pro bono meen dat hulle gaan nie vir jou enige kostes vra nie.
Ja.
So dit was die verstand, maar hoor nou mooi wat sê Hyder.
Ja, u kan vir hulle vra om vir u 'n rekening op te stel en vir u 'n gedetailleerde rekening te vra van hulle af om te wys watter werk dit is wat hulle sê hulle vir die gedoen het, wat nou natuurlik hierdie R10.000 se gelde opmaak. Maar soos Ashraf gesê het, as u dan na die taksasie toe gaan, dit is 'n taksasieprosedure, dan moet u dan aan die takseermeester noem, of u verteenwoordiger moet dan aan die takseermeester noem, dat daar was 'n ooreenkoms vir pro bono optrede deur die prokureurs. As die takseermeester bevind dat dit wel so was, dan sal hy vir hulle sê, of hy of sy vir die prokureursfirma sê, dat hulle nie geregtig is om vir u enige kostes te vra, behalwe die nominale bydrae wat hulle vooraf met u ooreengekom het nie. So as u dan kan bewys dat daar 'n pro bono is, as dit op skrif was, of as u getuienis kan gee vir die takseermeester dat daar wel so ooreenkoms was, dan sal hulle vir die firma nie toelaat om hierdie rekening teen u te takseer en van u te verhaal nie.
Dis reg, mevrou, en daar's ook regshulpklinieke daar waar jy bly. Jy moet miskien bietjie met hulle gaan praat om vir jou te verdedig in die saak, of om die saak voor te neem en saam met u te gaan na die takseermeester toe. Is dit reg, hè?
Dis korrek.
Okay. Baie dankie, mevrou.
Ja, sê vir my, wat is die Engelse woord vir die direkteur, die ene wat ek nou naartoe moet gaan?
Die takseermeester.
Ja.
Die Engelse woord is 'n taxing master.
Daar by die Landdroshof.
Ja.
Hulle het nou daai rekening vir u gegee. Dis 'n dagvaarding, sê jy.
Ja.
O, dan moet jy gou daar uitkom by die klerk en sê jy gaan dit verdedig. En dan vat daai dokument na die regshulpkliniek by die universiteit.
Okay.
Ek kan net bylas dat die regshulpkliniek of die persoon wat u dan sal gaan sien, sal dan vra dat hulle 'n rekening opstel en dit takseer, en hulle sal ook in daardie saak waar die dagvaarding teen u uitgereik is, sal hulle dan vra dat die kostes getakseer moet word, en dan sal hulle u gaan verdedig op die basis, eerstens dat daar 'n pro bono ooreenkoms is, en tweedens, as dan nie kan bewys word dat daar 'n pro bono ooreenkoms is nie, dan sal hulle die kostes op en neer op die basis van dat hulle jou gevra het vir goed wat hulle nie veronderstel was om vir u te vra nie, en dat hulle dan natuurlik daai kostes kan verminder as dit die saak is.
As die prys wat hulle vir my gegee het.
As die prys wat hulle vir jou gegee het, dis reg, ja.
Okay, mevrou, baie dankie. So that is quite an interesting little incident there. The lady was indigent. She said for a long time for an attorney. She found an attorney who said that he'll do the work pro bono. Pro bono means without cost to the firm, so they agreed to do it almost for free, almost on a disbursement only basis.
That's right.
They then engaged with the tenant for an eviction order, and they got the tenant to pay their costs for the eviction. And after that, and while our client, while the lady was in hospital at some stage, they issued now the summons, and now she's faced with the summons for an amount that she didn't authorize in the first place. So there was clearly no agreement, not even attorney and client cost here. There was an agreement that you'll do it for free.
That's right. As I see it, there was a mandate by the lady for the attorney to act, but not for him to charge her. And therefore, in court, if he persists with his summons, they will have to prove that there was a mandate, which, if there was a pro bono, and for instance, the lady can say that I've never made a payment to the firm. That's proof that there was no charges supposed to come to me.
And she made 60 rands or some
paid
nominal
a nominal fee
amount,
for the copies of the court orders or of the stamps or whatever it is, as you said, maybe disbursements.
Yeah.
And that would be part of her evidence, whether it be in a taxation or whether it be in a court case eventually, that she will use to say, I had a pro bono agreement and I wasn't expecting any charges to be raised for the work that was done.
Okay.
She might also even call the erstwhile attorney to come and give evidence in her favor that he had an agreement with her to do pro bono work.
And of course, the filed notes and things will all play a part.
Will all play a part in that.
So we were just talking about the possibility of recovering costs in a criminal matter, which is very, very rare, unless the prosecutor was malicious.
That's right.
And that's very, very difficult to prove that. Because, I mean, look, what reason would the prosecutor have to be malicious? Because the prosecutor simply gets the docket from the investigating officer or the control prosecutor, the matter is enrolled, and the prosecutor studies the docket, goes through the witness statements, and then engages in the matter. So very little chance of actually being malicious.
Absolutely.
We have another caller on the line. Please go ahead.
Hi, I just want to know, can I have a judgment rescinded on the fact that the costs were not improper?
Well, rescission of judgments have to satisfy 3 or 4 different requirements. And if your sole defense is that the cost itself was not proper, then it's very difficult to say yes, because you've got to show, one, that you were not in willful default of defending the action. 2, that you have a good and proper defense to the claim. It's what we call a bona fide defense to the claim. It's a but your question goes around, is it simply on the cost, or do you have other defenses?
No, cost, and also I believe I just recently discovered that set-off is a defense.
Did you have an arrangement with your attorney that you're going to set off?
No, I have a set-off. I have a counterclaim against the company that took judgment against me.
Yes, okay. A counterclaim is not set off. A counterclaim is your claim against that company, and it might be even more than what the company is claiming from you. But let's get clarity. Hyder, if I understand, an application for rescission where the costs are an issue, is that sufficient?
No, Ashraf, it's not. The costs can only be dealt with in a taxation. In other words, if you have a problem with the cost that they raised, it's your right to go and object to those costs in a taxation forum, but not in an open court seeking a rescission based on the fact that
On
the costs.
Is that right, caller? Do we understand you correctly?
Yeah, but also besides the cost, I have also issued summons against that company. So can I not apply for a rescission based on my summons and set it off?
So there was a judgment already. If you're talking about rescission, there was a judgment taken against you already.
Yes.
Yeah, but you still have to satisfy why the judgment was taken. So the first step, the first hurdle is this thing called willful default. What happened when the summons came to your attention? Where were you? How did you deal with it? Did you ignore it? Did you engage with the attorney? If you ignored it, then you're in willful default. Then it came to your attention, and the time in which to enter in the appearance to defend has come and gone, and you did nothing, or you know, whatever your circumstances. That's the first thing that the court will look at. Of course, in a rescission, it's not like a trial. The court looks at all the circumstances. The second thing is before before the rescission is, did you actually bring that application for rescission within the time limits prescribed? If you're outside the time limits prescribed, it's normally 20 days from the date of knowledge of the judgment. If you're outside the time limits prescribed, you're going to apply for a thing called condonation. You've got to say why you were late. Again, it's a hurdle that you have to deal with before we come to the actual merits, which is cost or counterclaim or whatever you may have.
All right. So I still have to prove my. If I do a condonation application, I still have to prove why I didn't do it within the 20 days.
The 20 days of the knowledge of the judgment, and then remember, I'm saying willful default of not having defended the summons timeously.
Right.
So that's a big hurdle, and I strongly suggest that you take the help of an attorney to deal with this matter.
Yeah, but can you just answer me? Set off is a defense.
Well, it's not a defense completely. I mean, it's you know, if you're saying automatically, oh, I have a counterclaim, therefore, you know, it's an automatic defense to the plaintiff's claim. It's not. It depends. It has to be bona fides. It has to be plausible. It has to be based on something concrete, and those are facts. Everything depends on the facts. Those are the facts that one takes into account to assess whether the counterclaim should be given equal light.
Right. Thank you very much for your help.
You're welcome.
You're welcome.
Okay, so I can't remember. I think we were talking about the costs on not in a criminal case, but we were saying that in the event that you have costs incurred, say for research, etc., we were talking about party and party.
That's right.
Costs. So photocopying costs, photocopying the file for an advocate is allowed.
There's provision in the tariff for it, but it has to be a reasonable amount of copies. If you go and copy documentation which eventually turns out to be irrelevant to the matter, that portion of the copies will be disallowed. But there is a provision for copies and a tariff for making those copies, if those copies are necessary and it's reasonable and proper to make those copies for that matter. So it will be allowed as in party.
So just to remind our viewers that our very special guest tonight is Hyder Rosslee, and he is an attorney, but he specializes in the area of drawing costs and opposing bills of costs. So as we've explained, this deals with costs incurred in a litigation process, and he comes from the firm of Rosslee, Lion-Cachet, and they operate in the Auckland Park area. You'd be able to find his name in the book. Alternatively, you'd be able to contact him through the Law Society or the producers of the show a little bit later on. Hyder, just to, we have very little time left. I'm told we have less than 4 minutes. Just to come back to quickly, and I know there's a lot of questions regarding costs. So in the event of, we were saying certain costs are recoverable and certain costs are not, and it all depends. I mean, a bill of costs properly drawn up should be able to give you at least 60 to 70% of your costs back in a litigation?
Well, Ashraf, again, like in all things law, legal, yes. It depends on the facts of the matter. Some matters, the bigger the matters, the less percentage-wise will you recover.
Right.
Because you will maybe have 2 or 3 counsel involved in a matter because it's big enough to warrant. You will not always recover all 3 counsel's accounts, advocates' accounts. Or you'll have 2 or 3 attorneys working on a matter, but the tax master will only allow 1 attorney. So in large matters, your rate of recovery becomes less and less percentage-wise. But generally, run-of-the-mill matters, yes, I would say anything between 40 and 60%, depending on the drafter of the bill and how the bill is presented. That is also important. If it's properly done, drawn up and presented at taxation, then obviously your rate of recovery will be higher.
Now sometimes the attorney that you consult has to use the services of another attorney in another part of the country. Let's say, for example, you're sitting in Cape Town and you have a matter in Cape Town, but you instruct an attorney in Johannesburg, and that attorney instructs an attorney in Cape Town to act for you. So surely, because you're in the same city as the matter and the second attorney, the attorney's costs incurred in Johannesburg, one of the 2 costs would not be allowed. Which one wouldn't be allowed?
Well, typically in this matter, the Joburg attorney's costs will not be allowed. But it's not as simple as that.
Yes.
If the Joburg attorney did certain work which would be recoverable anyway, would have had to be done by the Cape Town attorney, and the Cape Town attorney didn't do that work, then a combined bill would be drawn for the work done by the Joburg attorney, or those items or attendances that the Joburg attorney did, which is recoverable, and it would be combined with what the Cape Town attorney did. The rules specify that a litigant must employ an attorney where he lives or where he works. Sometimes you live outside of a city, maybe near a small town, and there's an attorney available there, so you can consult somebody there. Or if you live in a rural area and you work in a city, you're entitled to also employ an attorney in a city. And then, depending on where the matter is heard, if it's heard in the same city, then you're only entitled to 1 set of attorneys. If the matter is to be dealt with in a different jurisdiction, maybe from Cape Town to Johannesburg, then you're entitled to recover the cost of 2 attorneys if the tariff or if the rules of taxation allow for 2 attorneys to be employed.
Okay, well, look, unfortunately, we've run out of time. That's it for tonight. I want to take a moment to say thank you to Hyder Rosslee for having featured with us and given us a very, very important insight into legal costs. And to you, to the viewers, thank you for having joined us, and we will meet again at the next Legal Ease. Assalamu alaikum wa rahmatullahi wa barakatuh.